The Illinois Supreme Court heard arguments on January 10th, 2024 on whether the smell of cannabis alone can be used as a pretext to search a vehicle.
Good morning. The possession of cannabis has been legalized in the state of Illinois. The odor of marijuana is now an aroma of legality. The odor of cannabis emitting from a motor vehicle standing alone no longer provides a law enforcement officer with probable cause to believe that the vehicle contains evidence of a crime. Rather, the odor of cannabis now represents but one factor in the probable cause analysis.
Counsel, what statute are you relying on for your argument?
Principally, Your Honor, I rely on the Fourth Amendment of the U.S. Constitution and Article 1, Section 6 of the Illinois Constitution.
Transporting cannabis in a vehicle in a non-odor-proof container and using cannabis in a vehicle.
So it wouldn't give the officer probable cause if I'm just walking down the street and I smell like cannabis to search me.
This court would have no reason to.
Let's just assume it is, but that's what they're proposing. They're saying it doesn't give you probable cause to search. You're saying you can search a vehicle, but you can't search a person. Is that
right? Because the crime here is smoking a vehicle or using cannabis in a vehicle. And so if a person smells like cannabis while they're in a vehicle, that's some evidence that they use that cannabis while in the vehicle.
And are there any cases to talk about when a car stopped and police officers smell alcohol about the person?
Yes.
Do they have the right then to search the car?
No, this court has never said that the smell of alcohol alone allows an officer to search a car based on the suspicion of any number of alcohol violations.
In response to the court's question with respect to whether there's any jurisprudence or any case law on the issue, we cite within our brief a case that deals with the issue of the strong odor of alcohol coupled with an officer's observation of an open container of alcohol in a brown bag. So there was an additional factor. And that's ultimately the argument here. The argument is that the officer can consider the totality of the circumstances when determining what weight to be placed on the odor of cannabis, whether it's raw or whether it's smoked. That is a distinction of very little constitutional importance that our government is attempting to distract the court to focusing on. Because whether it's in an odor-proof container doesn't respond to the question of whether or not the odor of cannabis connotes unlawful transportation. It is a factor that the officer can consider in the probable cause calculus. Whether the cannabis is raw, whether the cannabis odor is burnt cannabis, is a distinction of little to no constitutional importance to this court's determination. Once cannabis was legalized, it wasn't legalized provided that it was smoked only. Once cannabis was legalized, the odor of cannabis in a motor vehicle, whether it's burnt or whether it's raw, must be only a factor in the probable cause analysis. It is not the be-all and end-all. The government essentially concedes that it's a totality of the circumstances analysis. In response to Your Honor's question with respect to the person walking down the street, and I realize that's not a person driving, but there are restrictions in the Recreational Cannabis Act that prohibit someone from consuming cannabis in a public place. But the government concedes if the officer is walking down the street and smells someone who smells of cannabis, the officer doesn't have a basis to stop and search that individual, notwithstanding the smell. Well, I think that concedes the point.
Counsel, in that calculus, is the smell of the cannabis and the very, very strong smell of cannabis, is there a difference between those? Does the gradation of that smell make a distinction that changes the calculus?
In and of itself, no. And the reason is because the detection of the olfactory senses, as Mr. Carman argued, is highly subjective and variable. And so the smell alone without more is not sufficient. I gave the example of the strong smell of burnt cannabis coupled with smoke wafting out of the vehicle, or perhaps ashes burning in the vehicle. That would be additional circumstances that would go into the probable cause calculus that might establish probable cause. But the smell alone simply can't be a basis for a search.
See the link in our bio. You can watch the entire hearing now on our Patreon page, absolutely free of charge. That's thecolememo.com/Patreon or the link in our bio.